Courts rely on legislative debates? Well, mainly because legislative committees in the California legislature have to process so many bills at their limited time hearings, there's little public debate, even among legislators, regarding bills that are heard in the committees of the state Senate and state assembly. Even on the floors of the Assembly and Senate in the California legislature, there's very little public discourse and rarely any detailed discussion, particularly about a bill's specific provisions. I find this to be particularly problematic when a statute is being considered by the judicial branch of state government and the judiciary is trying to ascertain the intent of the legislature. Unfortunately, state courts often find that statements of intent, as well as legislative debate, particularly detailed discussions about a bill's provisions, are sorely lacking. And yet, it's often those details that are at issue in litigation. Now, nonetheless, there are instances when a legislator's public statements may be considered by the judicial branch of government. In recently reading an interesting California Supreme Court decision, it's Walters versus Weed in 1988, a Cal Supreme Court decision. And here the High Court noted a principle of statutory construction in California. But then they explained how individual legislators' statements can actually be given weight by the judiciary. So the court explained, although there's a marked judicial reticence to rely on statements made by individual members of the legislature as an expression of the intent of the entire body, and they cited, for example, Friends of Mammoth versus Board of Supervisors, a Cal Supreme Court decision in 1972, they went on to explain that the Senate committee hearing transcript incorporating the author's testimony commands respect for two reasons. So the court said, first, we have in the past accepted an individual legislator's statement as an aid to ascertaining a statute's underlying purpose when the statement has given some indication of the arguments made to the legislature and was subsequently printed by the legislature. Here they cited California Teachers Association versus San Diego Community College District, a 1981 Cal Supreme Court decision. The High Court went on to say, second, the transcript reveals the discussion and events at the hearing, aspects which we may properly consider. Here they cited In Re Marriage of Bouquet, 1976 Cal Supreme Court decision, as well as a 65 Cal Appeals Court decision, Rich versus State Board of Optometry. The court said that discussion, which comprised a full day's testimony, indicates that other legislators and witnesses share the author's views on both the need for and the purpose of Senate Bill 1653. Now, while this California Supreme Court decision demonstrates that detailed statements can be relied upon by the judiciary when interpreting statutes, when those statements are provided to the legislature as a whole, I think that this could be accomplished by not only providing to other legislators an author's statement that broadly describes the purpose or need for this specific bill, but also ensure discussion about specific provisions of the bill, particularly ones that may be controversial or be the subject of serious debate. And those statements should hopefully be reflected in the committee and floor analyses in particular. Now, in other words, what's really in dispute or in need of interpretation by the judicial branch is the general purpose or intent of legislation. For example, this bill would improve or protect workers' rights. Instead, litigation and subsequent need for interpretation of an ambiguous statute by the judicial branch of state government is usually over some ambiguity or what does one or more statutory provisions mean. For example, why did this bill use regular rate of pay instead of a different standard for defining pay? Now, that's why legislative debate and discussion regarding a bill's main provisions is actually really important, particularly when a statute ultimately becomes the subject of litigation. As a result, I think that the debate and discussion would be more meaningful for litigants and ultimately the judiciary if points were publicly made regarding why specific words or language in the proposed statute are being used in this particular context. Additionally, statements should be made in committee and on the floor explaining a bill's provisions. This will hopefully demonstrate to the judiciary that other legislators agree with the author regarding the purpose and the intent of a bill's provisions, so that judges give great weight to those statements as well as whatever else is set forth in the legislative debate on that particular bill.